Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. This video today we're going to be discussing some recent policy changes with respect to how fraud and misrepresentation is construed with respect to U.S. tourist visas. In the past, there was a rule that was sort of colloquially referred to as the 30-60-90 rule, and basically this rule sort of stipulated, or this framework sort of stipulated, that a person entering the United States on a tourist visa, or a non-immigrant visa I should say, but let's go ahead and keep this kind of narrowly focused to tourist visas, who undertook something that would countermand or sort of counter the notion that they were a non-immigrant, or that they had non-immigrant intent at the time that they applied for the visa. So for example, like coming into the U.S. on a tourist visa and going to school, getting married and applying for adjustment of status to green card status in the United States, working without authorization. If this stuff happened within a 30-day period of that alien's arrival in the U.S. on a tourist visa, then it was presumed that that was prima facie evidence of fraud and misrepresentation. If it happened within 60 days, or between 30 and 60 days, whatever you want to call it, it wouldn't be considered prima facie evidence on its face necessarily, but it was considered something. Basically, questions would arise and the individual would need to demonstrate that they did not defraud the system, and that they did indeed have non-immigrant intent. It's just circumstances changed that would be on their control, essentially. And then finally, sort of after the 90-day mark, I guess you could call it, it was sort of all of this stuff. It didn't totally fall away, but you didn't have these presumptions being raised, rebuttable or otherwise. Well, that being said, there's been a new policy decision, new policy change with respect to a 90-day rule, which is being outlined by Department of State. Now, let me be clear, as of the time of this filming, or at least to the best of my knowledge, USCIS has yet to adopt this rule itself, but Department of State is using it moving forward. Excuse me. So from the standpoint of how they look at issues involving fraud and misrepresentation and the use of a tourist visa moving forward, the framework is such that if one does something within a 90-day period from their arrival in the United States that would basically counter the notion of non-immigrant intent, things again like getting married, going to school, working without authorization, etc. Basically within a 90-day period, they're going to go ahead and presume that that individual was misrepresenting themselves in their initial entry to the United States, and I'll get into that in a moment. Perhaps misrepresentation with respect to the application for a tourist visa, but also misrepresentation with respect to entry in the United States. And let's be clear, there's 2 points at which fraud and misrepresentation could be inferred. The first one is on the visa application itself. The other one is when one enters the United States, because when one enters the U.S. on a tourist visa, they are not implying, they're explicitly stating their intention is that of a non-immigrant, and in the case of the B1, B2, tourist visa traveler. They're not there permanently. So again, within 90 days after that arrival, they're going to go ahead, if someone does something that sort of is countervailing or is counter to the notion that they were a non-immigrant when they arrive, it's all going to be determined within a 90-day period. It's not going to be as chopped up. Now again, this is only with respect to Department of State, so we're presuming here that these are individuals who will have done something that was countervailing to their tourist visa status and then came back abroad. Now, this is not to say getting married in and of itself in the United States on a tourist visa is enough to warrant a finding that one doesn't have, or one was misrepresenting themselves. In fact, if one goes in the United States, gets married, and leaves and decides to process a case abroad, that's pretty good evidence that they weren't misrepresenting themselves. They were using the tourist visa as a tourist. They just happened to want to get married to presumably their American citizen or lawful permanent resident fiance in the United States. But that being said, basically the point of this video is just to make note of the fact that there have been some changes with respect to the way in which fraud and misrepresentation is inferred with respect to those using non-immigrant visas.